Thank you, everybody, for joining us today. We're going to talk a little bit about when you're an employee of a company and you're leaving, what happens to the issues of IP, things you created at the company, what you need to do as an employer, what you should do as an employee, and then as you go to a new company, what are some of the things you need to be concerned about? My name is Jubin with Dana Legal Services, and this is...
I am Marta Vanegas. I am with my law firm, Vanegas Law Group, and I'm doing a little bit different scope of work than Jubin. I don't do IP, I do small business and employment here in Walnut Creek, California, which is very sunny at the moment. It wasn't till 10 minutes ago, so apologies for the lots of sunshine.
Oh yeah, I've got the same thing. A lot of sun coming through the window. So if we are going to get started today, we'll basically start with kind of a question and answer session where I ask questions and then Marta tries to answer them and gives us kind of some general understanding. So at a very high level, when someone gets hired at a company, what are some of the things they go through that then causes the issues later on down the road in terms of employment agreements, contracts, and things they sign? So what are some of the examples of some things that people experience as they first get hired?
Well, I think it's very important from the company's perspective to have their paperwork in order, especially if they are hiring an employee to develop software or IP for them. And that's like a separate set of documents from the general hiring documents. So it's also very important to have your general hiring documentation done. So you need to make sure that you have an employee fill out an employment application. So at least you have their biographical data there. You know whom to contact in case of an emergency, that sort of paperwork. You have to have them fill out an I-9 form to say that they have legal status to work in the United States, and then submit the required documentation to you so that you are not in that kind of gray zone of like, I don't know what my employee status is. Now, of course, you can hire undocumented aliens. In fact, I would probably personally encourage you to do so, but it creates a lot of difficulties if they make a claim against you. So make sure that you're paying them very decently and that you document all the money that is going to them. Because if they make a claim against you and there is no paperwork, then you can be in a bigger trouble than you were hoping for. So a regular set of employee hiring documentation has to include that I-9 form. It has to include an offer and acceptance of some terms. If it is an hourly, then it has to state it's hourly. And in California, we have a requirement that you have to give your employees certain minimum information about their position. So what is their wage? When are they getting paid? So what are the pay days for the company, and who is the workers' compensation insurer? Because they have a right to make a claim of workers' compensation insurance independent of you to your insurer. They don't have to go through you. And I encourage all of you who are employers to have this phone number for your workers' compensation insurance available to your employees, because here is what happens. There is an injury and they don't report to you and they don't report it to the phone number either.
Okay.
Then you at least can say, if they were fearful that I would, stop them from getting benefit under this insurance policy, I already gave them his phone number. So they can go ahead and call that phone number, which indicates that I would not retaliate against them. And then, of course, please never retaliate against an employee who makes an injury claim, because people do get injured. And that's why we have mandatory workers' compensation insurance system to pick up those injuries. It's a very minimal cost. It's based on the volume of your payroll, and it's a percentage of your payroll. So it doesn't really matter how many employees you have. It matters how big your size of payroll is. Well, it's a fairly good system to suss out fraud also. So I encourage all employers need to have it. If you employ one employee, you have to have it. I encourage you to obtain the best coverage for you. It's going to make your life so much easier. So
Oh, go ahead.
these are the minimums that you need to have, right? And then of course there are these optional things that you should have. So probably you should have even low-level employees in the tech industry here and like the Bay Area, they do have to have an NDA, confidentiality. Non-solicitation and non-competes are not really enforced in California, but I would still put in that we are requiring you to not solicit our customers, because our customers is our trade secret. So if you put in a non-solicitation of your customers, you have to put it in like, we are making this requirement in writing, so you understand that our customers are ours and not yours. Even if you brought them to us, they are our customers.
What about non-solicitation with respect to other employees?
Yeah, I think that's fair. It should be limited in time, and most of these restrictive covenants need to be limited in time and geographic scope. With your employees, the geographic scope is kind of limiting them, but the time limitation should be sufficient to make it passable. And you should have that even with your consultants. So if you have a consultant coming in and takes a look at every single document and every single financial and every single employee, and then they would cherry pick who they like for their next client and recommend that next client to recruit or headhunt away from your employees, I think you should put there in your consultant agreement a very good non-solicitation clause.
So if you're hiring an employee, okay, so that kind of goes over the issues of things that they have to sign, especially as related to IP. What about if you're being hired? What are some of the things you should disclose as it relates to IP, so that your employer and you don't get into a conflict later as you're getting hired?
Well, if you are hired, whether or not you're hired to invent things,
Let's assume you are. Let's assume you are.
Okay, but the interesting is that it doesn't really matter if you are, right? Because if you have an invention that is out in the world, you have to disclose that to your employer, even if you are not hired to invent things. And I think it's a good thing to tell in the interview, I have a patent under my name, or I was an inventor on a patent that was granted, or a patent application that's filed and pending. It's a feather in your cap. So why wouldn't you tell a prospective employer that? But many times employees feel like it's not relevant, or it just doesn't come up. And then later they find out that it causes complications because they come up with an idea of an improvement while they are working for the new employer, and they never actually disclosed it, and the employer had no idea that this improvement does not belong to them, and now they have to negotiate or get into a lawsuit with the patent owner or assignee. So if you worked for somebody else when you invented that thing, then you have a continuous obligation to assign, and your employer should know that they don't really own everything, or they may have a claim. If you have an improvement idea, then the previous patentee may have a claim against this employer. Whether it's valid or not, that's a technical question or legal question, but why would you expose your employer to that risk? And they would be very displeased with you. And if you're an employer, it's kind of a good idea to ask if they are, working in a technical field, and if you're hiring them for sales of your technical product, it's a very good idea to ask if they have any inventions that are patentable that are in the pipeline.
Yes, because one of the scenarios that sometimes comes up is I was working at company A developing a particular product, and company B hires me to develop a similar product. How much of the new development, do I have to give to the company, and what would control that? Would it be the employment agreement? Would it be my obligation to my employer number A as opposed to number B? What do you think? Is there one document that can control that, or do you think it's multiple documents? I mean, how do we solve that problem?
Probably there will be litigation, but if you are employing someone in a technical position and their job is to create IP for you, then anything they create is assignable to you. So in the US, you cannot ever have a company as the inventor. It's always the inventor is the inventor, and the original patent right owner. But there is a right to that assignment with the employment relationship. And in copyright terms, this is the work made for hire doctrine. So when you are hiring someone to write a blog for you, or a blog, as we call it in the legal industry, it's a blog because that's what we are blogging about, the law. If you're hiring someone to write this, then everything they write in terms of copyrightable material therein belongs to the hiring entity. Now, in California, if you are hiring someone as an independent contractor, but you put in a work made for hire clause into your contract, then they are going to be classified as an employee for labor code purposes. I'm not sure if they are classified as an employee for other codes purposes, like the Fair Employment and Housing or Title VII, but for labor code, which can be quite serious consequence, they are classified as an employee if they are working in California. If they are working in another state, then I don't know. I'm not another state's attorney, and probably the enforcement is much more complicated then. But if they are working in California and create materials for you, they are definitely going to be your employees for wages and hours and overtime and that sort of stuff.
Is there
reimbursement of business expenses, which is a biggie. Yeah.
So in that context, let's say you do hire a contractor and they're going to do work for you and develop something for you. And that happened to be patentable technology that you want to go after. Are they obligated to assign it to you, or how do you control that to make sure that they assign it to you?
Well, you should not have a consultant do this, or you should have an employee do this work. But if it's a consultant who's like writing a special piece of the code, and you feel like they are not really your core operation, but they are writing this special piece of your product, then you put in a work made for hire, and you say that everything that they are creating for this work and every improvement thereof should belong to you. And I have a really broad clause that I drafted for this purpose that just lists basically every conceivable matters, and it's, including but not limited to, because we don't know what the future will bring. That should be able to control it, that assignment. I used to be as an IP paralegal, and my job was to track down the inventors and designers of various IP. And I can tell you it's really, really difficult to track some people down, especially with, like having, say, a European Union, huge territory, or somebody goes back home to India, and then you're trying to find a person in a country of 1 billion, or you're going back to China and it's even more than 1 billion people there, and it's really difficult to locate someone there. And then it's difficult to get the assignment to them, and then they have to sign it and have it apostilled, which is like a whole procedure.
Right.
So it's a very good idea also, when you are identifying what the IP is, to actually have them also sign an assignment while they are employed by you.
So
So it's
let's
the
take, oh,
NDA with the invention assignment. It's a very good umbrella policy that should cover you, but it doesn't really. So get those assignments, worldwide assignments of rights signed. The problem is when you're hiring them, you don't know what the IP is that they are going to create for you. So that's why you're creating this umbrella. And then once you identify the piece of IP, get that assignment signed, because I'm telling you, all the wrinkles I have is because I was tracking down these inventors and I had to speak Russian. I had to like dig out my childhood Russian because I was tracking this guy somewhere in Uzbekistan to sign something. It was really interesting.
let's say that you have a scenario. So in your situation, you're saying once you've identified that you're going to go after protection on some innovation, get the assignment as soon as you can. But let's say your employee starts the work and leaves the company before they finish it, and they finish it after. What do you suggest or recommend to the employer as this person's about to leave? Because I don't know, can you get an assignment on an idea that's not yet complete that they're still working on? Is that something you should do, or should you wait till it's completed?
So in your umbrella, when there is this like I agree or the employee agrees or whatever, however you phrase it. So the employee agrees to assign, and then the employee agrees to execute all necessary documents
Right.
that are needed for effectuating that agreement to assign in the future. If the idea is not, if it's so vague that you cannot put it in a documentation, then I don't know how you accomplish this.
Okay, so it's possible that you could write a summary of the idea and then get an assignment on that before they leave.
Yes, probably.
And
It has to be pinned down, and it has to
right.
be pinned down where is like, if you have the inventor's notebook, you have to be read and you have to understand what they are telling you. So it cannot be just like a vague idea. It has to be like, this is how we do it. These are the applications. So it has to be pretty concrete in order to be assignable.
Now let's do this. Let's say that, they're about to leave. Is there things you can tell them? Like, for example, can you tell them, we're not going to give you your last week's worth of wages until you sign the assignment, which is going to come 6 weeks after you leave?
Absolutely
Or,
not.
so
Absolutely
is there
not.
anything you can hold back? Is there anything you can hang on to force them to sign the assignment?
Discretionary bonuses are not required to be paid out to no longer employed employees. So if you have a bonus that they could have earned if they stayed with you longer, you can withhold those and pay them out, or you can have a severance agreement with them, with the portion of the severance payment paid out only after the assignment is executed.
Okay, so there are some things you can hold back, but some things you can't. What are the things you
cannot ever, do not ever try in California to withhold wages, not even a day, not even, it has to be paid to the employee who quits within 72 hours of their last day. No, if they quit and leave, then within 72 hours. If they quit with notice, then at the last day of employment, if they served out their notice. And if you are terminating them at the time of termination, so that's the pink slip, like here's your last wages
and your check.
And your check. Like here's how we classify this termination, whether it's a layoff or a firing or whatever. This is what you tell the EDD, that you got this paper, and here's your last paycheck. And that paycheck better be correct, because if you withheld any wages, there is penalties and penalties that stack up to 30 days of their wages, as if they were employed for 30 days. So that's 6 weeks, right? A month and a half of their salary continues if you don't pay them, as long as they are not paid their complete wages. So at one time we got, for my client who was the employee in that situation, there was $32 not paid out, but it was because the company was such a hot mess in their accounting that nobody could understand their commission system. And due to that, they made a mistake. They did not pay down the 32, but it was, of course, like they should not be making mistakes. Like it's their system. They should operate correctly. For the $32 that wasn't paid out, they had to pay almost $5,000 in waiting time penalties, which is a lot of interest on, on money. You multiply it and multiply it to get to $5,000. That was a good day for the employee. And the very sad day, I guess, for the employer, because they thought they did everything right, but like you have to have your system straight. And when you are paying someone on commissions, I'll get off of this soapbox, but when you're paying someone on commissions, that person better be able to look at a check and say, this is how hard I worked, and this is how many percentages I got. And if I work more, then I get this much more. If the commission system is so complicated that they cannot pin down how much they have to work to get more money, then it's not a commission system. It's just whatever.
Okay, so let's look at this as we're coming up to the half-hour mark. Let me ask two questions. One, if you're an employer, when someone is leaving your company, what are two important things you would suggest that they always check on when it comes to technical people who are doing innovation leaving the company? So what would you tell an employer who comes to you and says, hey, I've got a technical person leaving my company. Give me 2 points that I got to look out for.
I would want that employee to allow that I audit all of their tech at home.
Okay.
So their phone, their home computer, their laptop. It is not going to be audited by me, the employer. I'm going to hire a third party, and the third party will let me know what they find, because it's very, very easy to take stuff out. When I started law school, these USB drives were about the size of a thumb, so we call them thumb drive. Now they are the size of, I think they are less than the white on my nail. Like they are super tiny. It's super easy to email stuff. It's super easy to put stuff in the cloud. But odds are there would be some breadcrumbs on their home and personal devices.
Okay, so the 1 point is to have an audit done of all the tech that the employee owns or is used. What would be the other point you'd suggest?
Now, of course, this is a very broad thing. It is more, I would actually audit probably the employees' transactions on whatever their email is and their web use at work, to see if I really need to go to their home computer, if I really need to go to their laptop. But this is something that would be on my mind, just to look at how they were using before they were leaving, how they were using the computer, how they were using the web, how they were using the company email.
Okay.
I would definitely want to take a look at their cell phone. And if they have child porn on it, sorry, not sorry. But I would have a third party investigator audit their tech usage. So that's one thing.
Can the employee refuse?
Yeah, they can. Then you know.
If they refuse, how do you get it done?
You don't get it done. You sue them.
You sue them and try to get it done that way.
Yeah, so, you are like, why are you refusing? Did you take stuff?
Right. So one point
you may want to put this in your employment agreement that, you know.
Oh, okay, up front. So
we are going to, if and when you leave our employment, we are going to give you a laptop. You are not allowed to use your home computer. If we think you may have used your home computer, we are going to search it. We are going to have a third party search your home computer. You may, bring in a cell phone to the office, but the price for bringing in a cell phone in the office is that we may audit your cell phone. Or you can have a locker and lock your cell phone in there or leave it in your car. So that's a serious issue. I think odds are you will find a big fat nothing, and then you can go home and sleep soundly.
What would be your advice on the flip side? If an employee is leaving and they're getting ready to leave the company, what would you recommend to them as 1 or 2 points to be aware of as they're getting ready to leave?
So employees don't really know this, but HR is not really on your side, and your computer at work is not really your computer. Your email is not really your email.
Right.
Your phone is not really your phone. Everything within the four corners of your employment relationship belongs to your employer. So don't save your job search stuff on your work computer, and don't send home any technical materials because you were interviewing at work and now you have to finish your work at home or whatever, because they're just gonna come and bite you. You may have very good reasons to do so. Don't then stay late at work. Just be very mindful of what you do. Don't send up these red flares that you were trying to take trade secret or or
Technical
other
information.
technical information, or you're engaging in industrial espionage on the company's finances or whatever, because there are people who do that and you don't want to be swept up with them in that same class. So
Perfect.
be very careful how you behave. It's fine if they think you're interviewing because you're that well dressed, but just don't give them reasons to think that you are actually taking stuff with you. Don't contact their customers and let them know that you're going and there is going to be somebody else taking care of them. You are not the company's PR, and the company has a right to manage how they let their clients, their customers know.
That's right.
And it is also their duty. If you want to send out an email about you leaving because, say, you are going to leave for college or, oh, God forbid, law school, then ask for permission to do so. If you're going to a competitor, it is absolutely forbidden. Don't even ask. Your employer is not going to want it. Just go to your competitor and make a good living there. Don't try to take customers with you. If the customer really wants you, there is a vast thing called the internet. They are going to find you without you saying a peep. Feel free to update your LinkedIn profile. And if they really want to work with you, they will find you, but don't contact them.
What about if you contact them after you get to the new employer? So let's just say you decided not to do anything, you get your new job and you call them and say, hey, I'm at a new place.
No.
No, don't do that.
No,
Okay.
Because you knowing them is a fact that is, but for you working for your prior employer, you would not know that. If you brought in that client, then conceivably, if you are not ready to bring in a client and say, this is now my employer's client, then don't bring in the client, because odds are you are going to lose in that fight.
Very good. Perfect. Well, that was great. Thank you for answering the questions and going through that exercise.
Anybody in the audience?
Do we have any specific questions, Nicole?
Not today. Those were
that we were so complete. We are completists.
All right, we can end this one.
Thank you so much, everybody.
Thank you.